Everyone, and a warm welcome to this virtual Rule of Law lecture and panel discussion, which is jointly sponsored by the Schulich School of Law at Dalhousie University and the International Commission of Jurists of Canada. My name is Camille Cameron. I'm the Dean of the Schulich School of Law at Dalhousie, and it's a pleasure to be able to welcome you all today. We're a co-sponsor of this event, and as I say, we extend a warm welcome to everyone. I'd like to begin by acknowledging that I'm speaking to you today from Mi'kma'ki, the ancestral and unceded territory of the Mi'kmaq people. This territory is covered by the Treaties of Peace and Friendship, which Mi'kmaq and Maliseet people first signed with the British Crown in 1725. We are all treaty people. I would ask everyone please to take just a moment to consider and quietly pay respect to the traditional owners of the land on which you are located today, wherever you may be. The title of this lecture, which will be delivered by Dalhousie Professor Emeritus Wayne MacKay, is certainly a fitting one in light of the times in which we all find ourselves. That title is The Rule of Law in Pandemic Times. It is a fitting title for various reasons, including the commitments of the sponsors, the International Commission of Jurists and this law school, to respecting, advancing, and thinking, teaching, and writing about the rule of law. It's also fitting because, yes, we are in a pandemic. Where we are on that pandemic continuum, if there is such a thing as a pandemic continuum, is an open question. And I'm going to leave that to the experts, to the virologists, the immunologists, and so on. And as I was thinking about this earlier, I thought that perhaps it's not a continuum at all, but in fact, a roller coaster. In any event, we're all aware that the pandemic has given rise to new legal issues, that it has brought other legal issues and controversies that might previously have been in the background into the foreground, that it has presented new legal challenges, and that it has highlighted stark and deep inequities across various groups in our societies. We've assembled an excellent group of experts, Professor Wayne MacKay, Professor Sherry Pictou, and the Honorable Thomas Cromwell, to address some of these issues. Now I'm going to turn things over to Ms. Minette Maillet, the Executive Director and General Counsel at the Office of the Correctional Investigator at the ICJ, to introduce our keynote speaker and our panelists. Ms. Maillet has a distinguished record of legal service as a civil litigator and a human rights advocate, expert, and leader. Thanks everyone for your interest, and I'll now turn it over to Ms. Maillet.
Thank you very much, Dean Cameron. I want to welcome everyone and thank you so much for joining us at this first annual Rule of Law lecture organized by the International Commission of Jurists in partnership with the law school. As a Dal Law School alumni myself, I'm delighted that our first ICJ Law School Rule of Law lecture is happening here or over there in Halifax at the Schulich School of Law. I am, as Dean Cameron said, Executive Director and General Counsel at the Office of the Correctional Investigator, but I'm also in another role as Vice President of the International Commission of Jurists Canada. I'll be moderating today, and I'm honored to do so with such an esteemed panel and on such an important and timely topic. I want to take a minute just to briefly explain what the International Commission of Jurists is all about. It's been around for a long time. It was established in 1958 by the legendary Chief Justice of Canada, Ivan Rand, and other leading former judges, lawyers, academics, and human rights champions. At ICJ Canada, we seek to promote greater understanding in Canadian society of the rule of law, human rights, and non-discrimination in the operation of our laws and institutions. Given the challenges to the rule of law we have witnessed in recent times, we feel strongly that this awareness raising is important work that must continue in order to ensure that we do our part in preserving a healthy democracy. And we do encourage participants today to join us in this endeavor and to become active members of ICJ Canada. There's my little call out. I encourage you and those in your networks to check out what we do in promoting the rule of law at icjcanada.org. And for those who are not already members, you can join online. We will be making the recordings of this event available to present and future members of ICJ Canada. Now, before I introduce our keynote speaker, Dr. Wayne MacKay, I'll let you know briefly what today will look like. His keynote lecture will last about 45 minutes. Then each panelist will comment for about 10 to 15 minutes each before I turn it back to Wayne MacKay to respond to what he hears for about 10 to 15 minutes. And if we have any time left, we will take questions from the audience, and that can be done through the chat function of the webinar at the bottom of your screen. So I now have the pleasure of introducing Dr. Wayne MacKay. Wayne is a professor emeritus at the Schulich School of Law at Dalhousie University in Halifax. He taught law at Dalhousie from 1979 to 2017, with various leaves of absence to be director of the Nova Scotia Human Rights Commission from 1995 to 1998, and president of Mount Allison University in New Brunswick from 2001 to 2004. His areas of expertise include constitutional law, human rights, Charter of Rights, privacy law, cyberbullying, education law, and administrative law. He is widely published in all of these areas and has headed various government inquiries on topics such as inclusion in schools, sexual violence on university campuses, cyberbullying, and university governance. He was inducted into the Order of Canada in 2005 for his work on human rights in Canada and received an honorary Doctors of Law from St. Mary's University in Halifax in 2015. Professor MacKay also received numerous teaching awards and many since his retirement in 2017. He is an active commentator on a wide range of legal topics in all forms of media at the local, national, and even international levels. He is also a member of the Nova Scotia Bar and has litigated some leading cases on the Charter of Rights. Wayne received the Queen's Counsel designation in 2013. And without further ado, I'll turn that over to you now, Wayne, for the lecture.
Well, thank you very much for that very kind introduction. And I want to start by thanking the International Commission of Jurists and the Schulich School of Law for giving me the honor of doing this first lecture. As Dean Cameron indicated in the introduction, that the topic is a timely one in terms of the role of law in pandemic times. So, and I want to welcome those of you who have signed on to listen to this, and I hope it will be interesting and useful to you. So thank you very much for that. So without further ado, I will begin. So the first point I wanted to explore was the COVID pandemic, a case study in balancing rights in a health emergency. And to some extent, that's really the sort of approach to this lecture, is where does the role of law fit in relation to this kind of an emergency? It's perhaps an obvious point to say that COVID-19 is a major challenge, and in fact is probably the biggest crisis that we have faced since World War II, and some might even say more than that, but certainly it's a major challenge. On the other hand, it's also an opportunity to think about how we can respond to this, think about, as we mentioned in the defining moment point, think about who we are as people and who we are as a nation. And I guess it kind of gives some weight to that argument that in difficult times, the real character and nature of people and perhaps nations comes out. And so in that sense, I think it is a defining moment. The essential challenge in this time is balancing rights and values, because there's a lot of various rights being limited, both at a collective and individual level. And I think that's really the major challenge that faces everybody, not just the courts, but the legislatures, the administrators, and the courts, and the various administrative agencies. Another basic point on balancing rights is, of course, rights are not absolute. rights do have limits, and the challenge is to decide where we strike that balance on limiting rights and giving effect to rights. And that's the core issue. The Charter, of course, has now become an important part of that. And in particular, it's significant to note right at the outset that the Canadian Charter of Rights and Freedoms, in its very first section, recognizes that there are reasonable limits on rights in a free and democratic society. It puts the burden on the government to establish that, but it recognizes it. And in the famous Oakes case, the Supreme Court of Canada set out their approach to that. So, ironic aside, Justice Cromwell and myself, or former Justice Cromwell, wrote an article about Oakes. That was one of our earlier connections. And the Oakes case, of course, establishes essentially you can only limit rights if you have a pressing and substantial objective and you pursue them in a proportionate way that's rationally connected, minimally impairing, and balanced. So that's basically what the structure is. That same kind of balance indirectly plays out in other areas of the law as well, statutes, common law, regulations, not exactly in that form, but you have rights with exceptions. And finally, the Charter has now been integrated as an important part of the rule of law. So that's a rather new element. It's not the only element, but an important element of the rule of law. Next slide. So the second point I want to pursue is the rule of law and authority for restricting rights. And before I get directly into that, it's important to note that the concept of the rule of law is expanding. And as many of you in the legal world would know, the rule of law is one of Canada's underlying constitutional principles, recognized in the Quebec succession reference, along with federalism and democracy and protection of minorities. But I guess not everyone really knows what that means. So I thought I should pause and say, what does the rule of law mean? And interestingly, the first real clear articulation of that may have come from Ivan Rand, former Justice of the Supreme Court, Ivan Rand, who I understand is the founder of ICJ. And in the famous case of Ron Corelli and Duplessis, where then fairly dictatorial Premier of Quebec, Duplessis, was using the powers under the Liquor Licensing Act to punish people who supported the Jehovah's Witnesses. And as part of that case, saying that that was not acceptable, he set out some of the core ideas of the rule of law, that no man is above the law, that the rule of law is really about a stable, ordered, and predictable society in which laws, not individual whims of people, prevail, that the courts, among others, are to be a shield against abuse, and perhaps most significantly at the present time, in time of crisis, is that no discretion, however broadly stated, is unfettered. So I think that's the core concepts that come from that. Who promotes the rule of law and who balances? Fairly traditionally, and former Justice Cromwell has written about this as many others have, it used to be the courts that were seen as the main and only real bastion against abuse, and that the executive were the abusers. But we've come to, I think, a more enlightened approach that all three branches of the state, the legislature who makes the law, the executive who enforces it, and the courts, as well as administrative agencies, as a partnership, are the ones who promote and balance the rule of law. And who's accountable to whom? Obviously, the executive should be accountable to the legislature. That's what normally happens. That's more difficult in COVID times or in pandemic times, because in Nova Scotia, the legislature was suspended for a significant length of time and various limitations put on other ones, which then means that other agencies need to make the legislature and the executive more accountable, not just the courts, but various administrative agencies as well. And a large part of what we'll be talking about and considering is the balance between collective rights and individual rights, as already alluded to. Next slide. Okay, the rule of law and authority and restricting rights, as I say, is what I'm dealing with, but the core of that is the exercising of emergency powers. And in a federal structure, the first question you have to ask is the constitutional one: who has the major authority? And it's actually might strike someone as fairly ironic that most of the significant responses to the global pandemic that is COVID-19 has been at the local and provincial level. And part of that is the Constitution. Both levels of government have jurisdiction over health and different aspects of health, but the majority of the frontline role is one for the provinces. The federal government does have some significant roles on funding, setting national standards, and other kinds of roles. But it's important to note that in this COVID crisis, the federal emergency power was not triggered, and the peace, order, and good government, a jurisdiction not used to expand the federal jurisdiction. Some have been critical of that, but I won't get into that now, other than to say the provinces are, and the local level even, are the key players. Another key component of authority is the centralization of power. And in any kind of a crisis, be it war, health emergency, COVID in this case, because things have to happen quickly and you don't have time for great debates and discussions, power tends to get centralized. And in the COVID context in particular, the power has been heavily centralized in the health bureaucracy, and particularly chief medical officers of health, but also the traditional forms as well, cabinet and others. And whenever you have that kind of centralizing of power, there are potential issues. Final point here, the complex web of laws, that the laws themselves take different forms, statute law, and most provinces have had two major categories of law, health protection acts and emergency management acts, which have been used. But in addition to those which have very broad powers to search, detain, all kinds of quite extensive powers, a lot of power has been delegated to the cabinet, to the chief medical officer of health, and to the various bureaucracies. So that's really the major first two categories. The final one is what some people call soft law, sort of quasi-constitutional law, and this is quite important. Things like recommendations, press releases. In the Nova Scotia context, our former Premier Stephen McNeil famously said, "Stay the blazes home." But what was that? What was that statement? It wasn't really a regulation. It certainly wasn't a statute. It probably wasn't even really law as such, but it is a kind of soft law that sometimes came out in the form of press releases and other kinds of things. Next slide. So the rule of law challenges, well, as I've kind of hinted, especially this centralization of authority and this delegation of authority leads to lots of potential challenges, because it's a difficult thing to manage a crisis on the run. And it has to be enforced at some point when you're making orders and issuing press releases and so on by the police, which are brought in through other statutes, sometimes by bylaw officers, and all done in a very hurried kind of way. So it's important that the enforcement be as good as possible in that circumstance, but it does lead to lots of challenges. The other point is that there's certainly a need for tough choices to be made. And I think one of those tough choices can be demonstrated by using as an example the Taylor versus Newfoundland case, which was one where a woman actually in Halifax at the time was not allowed to attend the funeral of her mother, who had died just a day before the lockdown had occurred. And she challenged that under various charter sections. Well, she challenged it under division of powers and the charter, and was told at the end of the day that the health and well-being of the citizens of Newfoundland prevailed over the issues of her sort of sentimental, or not sentimental, legitimate concerns and empathy for her parents or the death of her mother. So that's one example of the kinds of tough choices that we have to deal with. Next slide. So enforcement of rules, as I hinted at already, is critical. And in addition to the fact that you have various agencies trying to do it, such as police and bylaw officers, it's obviously vital as part of the rule of law that enforcement be non-discriminatory and fair. But that is not easy in these kind of times. And the challenges of operating in a crisis, as I said earlier, is really one that's difficult, but it has to be done in the right way. The rules have to be flexible enough to change with the times. And if the COVID emergency has taught us anything, is that things change quickly, and the discretion has to be very broad. But as former Justice Rand reminded us and Ron Corelli, however broad the discretion, it can't be completely unfettered. So again, we have the important role for courts and other agencies to strike that right balance. And finally, fortunately, we have agencies, many agencies such as ICJ, but also the Canadian Civil Liberties Association, which has taken on the role of collecting together stories of abuse of bylaws and order power, stories of reports about the best way to respond, which they said was education, not punishment, and litigation, much of which is pending. Next slide. So the other comment that was alluded to briefly in the Dean's introduction, everybody's been affected by COVID-19, but some are affected much more than others. And a crisis like COVID itself and the restrictions tend to have a disparately negative effect on the vulnerable people in our society, whether they be visible minorities, Indigenous people, women, in terms of, I mean, a simple thing as saying stay home can be very negative for a woman living in an abusive home or children living in an abusive home. Many other categories which we'll explore later, but there's definitely not an equal impact. This can lead to a number of challenges, some of them human rights challenges before the Human Rights Code, because many of those vulnerable categories are prohibited grounds under the Human Rights Act, not all of them. And so they can be raised, especially with the recognition after the O'Malley case that human rights can be violated by impact or effect as well as intent. So whether or not it's intended, it can be a human rights complaint. And there's some advantages in terms of access and cost of going that route. So that's one possible avenue of redress, not likely to come during a crisis because people are otherwise occupied, but maybe later on. Charter challenges under Section 15 equality, and these are a little more expensive and certainly more time consuming, a wider range of remedies. But one of the challenges in that area is that the challenge tends to be after the fact, after the discrimination. We haven't gone very far in imposing a duty on governments to provide equality preemptively, if you like. So while it's important, it's got its limits. Challenges based on Section 7, life, liberty, and security of the person. That has some options as well, because many of the restrictions, as we'll develop in a moment, are on liberty and those kind of issues. But there, again, preemptive use is fairly rare, although Sujit Chowdhury made an argument, which I think is an interesting one, that maybe Section 7 does impose a duty to protect. And he argues that in a COVID context, that could apply to vulnerable people, so that one might try to use Section 7 in that way as a sort of a proactive and affirmative duty to protect, particularly for vulnerable groups. He uses as a possible reference for that the Bedford case in relation to prostitution. And finally, just on this little section, interlocutory injunctions, most of the cases, which I'll review in a moment, to date have been interlocutory injunctions because people want quick results from them, and that it's an urgent situation. But it's important, given that, to recognize that there's a very high standard to get an interlocutory injunction or a temporary injunction. The merits don't necessarily get argued at all. And in short form, you have to have a serious issue to be tried. So that's the content issue. Irreparable harm has to be shown, and you have to get the right balance on the balance of convenience. So that, just to set out, many of the cases come in that form. Next slide. I picked out 3 of many possible examples of vulnerable groups and how they're impacted, the homeless being one. And that's quite a timely one in some ways right now. I believe in Nova Scotia, the case starts tomorrow, where in the Halifax, people who were living in tents and homeless temporary shelters were evicted, and now that's being challenged in court. There was an earlier case in Toronto as well, where tents and temporary accommodations were put up, and the police removed people, and that was challenged under various charter sections, 7, 15, and also 12 for cruel and unusual, but it did not succeed. They tried to get an interlocutory injunction, but said it did not succeed at the end of the day. So those kind of cases are there. There was one positive note in Quebec where a curfew was not applied to the homeless because they felt that would be undue hardship. Obviously, it's hard to be at your home if you don't have a home. So they recognized that kind of self-evident thing. So I think we'll be interested to see how this plays out. But the homelessness issue is a big one, especially in COVID times. Hospitals and nursing homes. The nursing homes, maybe I'll start with that one first, were a huge source of grief and tragedy for all Canadians and worldwide to some extent, but Canada had a fairly large problem on that, especially in the early days of COVID-19 with so many deaths in nursing homes. So again, that raises important questions of, what should have been done ahead of time, what kind of restrictions perhaps should have been used. And there's a couple of cases, at least if not more, going forward as negligence claims in Ontario for inappropriate handling of nursing homes during COVID-19, and at least one class action lawsuit in Nova Scotia, and I'm sure in other provinces as well. So, and again, that's a classic vulnerable population, both because of the age, which itself is a prohibited ground of discrimination, but also the vulnerability at a health level of the people, the residents, and everyone in the nursing homes. Another, perhaps less obvious, but hospitals are another one. And there's a number of cases already dealing with hospitals. One, the Sprague case, the government passed a memorandum limiting visitor rights, and that was challenged as violating the Section 7 and 15 rights of the residents who would have been visited, and did not succeed. Based on, again, seeking an injunction. It did not succeed based on not meeting those kind of tests. An interesting aside there, the review that was sought could not be pursued because this was one of those soft law cases. It wasn't pursuant to statute, so they couldn't even fully review it. So that was one case. Another couple of cases that weren't directly in the health context. One was a group home where out of a 14-year-old who had various challenges of mental disability was not able to have visits. He could visit online or virtually or drive-bys, but not otherwise. That was challenged in the Ontario Human Rights Court. And interestingly, they said that they should have allowed visits in that case, that the duty to accommodate did not produce an unreasonable hardship, or so that he should have in fact had visits. And finally, in the prisons context, first of all, a shout out to Professor Adeline Ifteen from Schulich School of Law. She's done an excellent study looking at some of the problems there. Prisons, obviously a dangerous place for one in times of COVID. And the arguments are twofold. One, governments didn't do enough to protect prisoners. And secondly, and this is a class action suit, I think, led by the John Howard Society in BC, saying they had too many restrictions, so many restrictions dealing with COVID that prisoners' life was virtually unbearable. So that's really not something that they could cope with. So next slide. So first of all, it's important to note that the situations I just described are ripe for legal challenges. Charter and rule of law and other kinds of ones, you have concentrations of power and people moving at a very quick speed. So there already have been, and there will be a lot of challenges. A lot of people suggest because there are infringements and there are rights violations that obviously or rights limitations, that's going to be a charter violation at the end of the day. That's not necessarily so. And as in some of the cases I'll talk about in a moment, you'll see many of the cases to date have made a kind of Section 1 balancing, saying, yes, of course, rights are being limited, but in the name of protecting the larger society and the health and well-being of the larger society, it's not at the end of the day a charter violation, or not at the end of the day a rule of law violation. So there may be fewer violations at the end of the day than many people think. Another prediction I think that a lot of people make is that whatever balance the legislature or the executive have made on balancing collective and individual rights, the courts will strike a different balance and be much more rights focused. I'm not sure that's entirely true in the way that people tend to predict, because as it says, judges in the COVID world, sounds like a title for a book or something, but judges that are aware, as everyone else is, that we live in a time of COVID-19 and a pandemic, and using the balanced approach of our charter and others, I would say, and the cases to date support this, will be pretty deferential and open to accepting limits on individual rights on a temporary, hopefully temporary, basis while the crisis lasts. So I think that's important. From a government point of view, you can have some sympathy that they are, if to use that colloquial phrase, damned if you do and damned if you don't, that there's two levels of complaints, one that you didn't do enough, such as in the long-term care settings and others that you did too much. Your restrictions and orders and bylaws went too far and are unduly interfering with the rights of individuals. So that's the dilemma they face. Next slide. So I'm going to move from that to some quick review of some of the categories of cases to date. One, not surprisingly, is on mandatory masks. And the first one is in a religious context. The first one I want to refer to, Ingraham versus Alberta. And this was a case where the laws required the wearing of masks in church. And there was an objection brought to the courts by the religious community saying that that interfered with their right to sing, their ability to hear and communicate, and to properly reflect the glory of God through facial expressions, and that it was unduly limiting and therefore should be struck down as violating freedom of religion. The court did not see it that way at the end of the day. They were understanding of the religious limits and respectful of that, but felt that the health concerns prevailed. So that's one example. A pair of human rights cases dealt with masks in stores. One was a case where the customer case where the person who didn't want to wear a mask simply alleged that they had a medical condition or a disability that allowed them not to wear a mask. And the courts, the tribunal said that is not enough. You have to have some medical proof. If you have some medical proof, of course, we will accommodate that, but you can't simply allege it, and you can't simply not wear it because you don't like that or you don't think it's fashionable or whatever it may be. A second one, Baudouin, involving Costco and People's Jewelers, was a customer not wanting to wear a mask and insisting on their right to do so, again, claiming creed and religion, but and lack of adequate accommodation. The tribunal in that case said that they did properly accommodate because they offered other services such as online ways of buying, curbside service, and other forms of getting the goods without being in the store. So that was, in fact, alternatives that produced a reasonable accommodation. And the clear winner for the bizarre case of this presentation, if not many others, Miller versus Edmonton, which is, I think, obviously another Alberta case. A person brought a case challenging the existence of all the discarded masks as a case of nuisance and a violation of his Section 7 security rights under the Charter, because they created an environmental hazard to him and others. And the damages that he sought, if you hold it for a minute, was $565 million. And so not very surprisingly, the Alberta Queen's Bench dealt with that one pretty quickly, saying that you have no basis in law for your claim, and your claim for remedies is rather ridiculous. Which then brings me to business closures, and just one case on that. During the reopening in Ontario, the Hudson's Bay Company versus Ontario AG raised an interesting case that played out in many provinces, that big box stores and other stores selling groceries were allowed to stay open, but equivalent big box stores such as Costco or People Jewelers or others were not, even though much of the other things they sold were the same. And in these big box stores, people could buy not only groceries, but other items. And that was challenged really in a kind of rule of law way of saying that that was contrary to the purposes of the act and contrary to the rule of law. The short answer that they came up with at the end of the day was, well, it was probably unfair. Unfairness is not a basis for striking down regulations. And it's a classic example of deference that they would defer to the legislative and administrative authorities on reopening Ontario as to what kind of places needed to be closed and what kind of ones had to be open. So unlike Ron Corelli and Duplessis, this was an exercise of discretion within the statute. Gathering restrictions is the next one, and that's a large category. Again, I will start with a religious example, Springs of Living Water versus Manitoba. And in that one, this involved a rather creative response to COVID. The religious group had drive-in church ceremonies with a sort of like a drive-in movie screen where the service was offered. But they ran afoul of the rules in Manitoba at the time that you couldn't have more than 5 people together at a time. Now, they tried to argue as long as there were fewer than 5 in the car that they met the requirement. The court rejected that, saying the rules really required not people to make up their own restrictions, but rather to follow the ones set down by the government, and that the people claiming the violation failed to prove a couple of things. First, that being in cars was a vital part of their religion. And secondly, again, on the alternatives point, that it was all those services were also available on YouTube, also available on various other forms of media, so that the meeting in cars with the various risks that went with that were not sufficient, were sufficient rather to not strike down the rules. It established an interesting point on the freedom of religion claims that you do have to prove that what you're requiring goes to the religion. Another interesting little case of that was one concerning a community of Hasidic Jews in Quebec. And this one was one where there was a rule of 10, no more than 10 gathering for any purpose, including worship. But the building that this particular group collected in had separate rooms with separate entrances. And they argued that the rule should be struck down because clearly they should be able to do that. They actually won that one because the court, using their power of statutory interpretation, said the rule is broad enough and it would be consistent with the purposes of the rule if each room was treated as though it were a separate house unit, because that didn't pose a risk to others, and therefore that was the proper interpretation. So the next area is dissent and free speech, or issues around that. I guess, there's one more before we get that. Public protests, another form of gathering restrictions. The Baudouin case said that there was a challenge there in BC, which partially succeeded, where a group was wanting to, anti-vaxxers and anti-mask people, wanting to protest against the rules. And mostly they did not accept it and allowed the injunction to go forward, but they made some exceptions in the BC case. In Nova Scotia, there was a similar challenge, Nova Scotia versus Freedom Nova Scotia, an anti-mask, anti-vax group who were protesting as well. And in that case, in a very broad injunction granted in advance of the hearing or the demonstration, they found that the government's position was supported. That was strengthened by a strong affidavit from the Chief Medical Officer of Health, and probably particularly fortified by the fact that it was pretty clear, and the people planning to protest made it clear themselves, that they were going to violate the rules. They were going to flaunt the law. They were not going to wear masks, not going to physically distance, none of those kinds of things. So it was granted in May. By June, the government asked themselves to remove the injunction. So, but I believe it may still be challenged at some future point. Now moving to dissent and free speech. A case out of Ontario, R versus Skelly, raised another interesting case. A Toronto owner of restaurants, I think various barbecue restaurants in Toronto, when all those kind of establishments were closed down, went on social media to proclaim that he was flaunting the law. He didn't use that term, but that's what it amounted to, saying he was going to remain open in spite of that, urged people to come out and eat, and they did so in large numbers. Not surprisingly, they closed him down. He then challenged it, and he challenged the ruling made at the time, which was that he was to have no access, or virtually no access, to social media, the kind of thing that they did to former President Trump, or maybe even broader. He challenged that and had partial success. Not at the end of the day. They said he couldn't use social media to advocate violating the law, but they had to give him sufficient access to social media to make political protests and to advertise. So that's a rather interesting case of balancing individual rights and collective rights in a sensible way. Next slide. Curfews and lockdowns, another big area, although there's not a lot of cases. There was a curfew established in Quebec from 8 o'clock at night to 5 in the morning, very far-reaching one, which was challenged unsuccessfully, again, seeking a interlocutory injunction, and it failed mostly on the third part, that the balance of convenience and the risks posed supported even drastic measures such as the curfew, even though it was pretty far-reaching and was limiting mobility and detention. There is another case coming forward that will get to the merits, which is rare. This was an interlocutory injunction. The actual merits of that kind of case in Marc Boris versus Saint-Maurice and AG Quebec, that one is being heard in the Quebec Superior Court in the next few months. So that's where that one stands. On travel, I've already alluded to the Taylor versus Newfoundland case where the person was not allowed to attend their mother's funeral, and that was upheld on a number of grounds. I mentioned division of powers, but also on the charter. Interestingly, in that one, the Section 7 rights which were raised, they said failed on 2 counts. To use it in this way would overlap with Section 6. And secondly, and this is a bit odder one, that attending your mother's funeral was not a fundamental personal choice. But I'm not so sure about that, but they had already decided that anyway. It was also challenged on the mobility rights under 6, but there again, they said that the limits on that, and particularly the reasonable limits on that, were sufficient, that that really was not necessary. Another case, just in a comment, Monsanto also dealt with one of crossing borders and those kind of things, but I think I'll leave that for another time. Isolation and quarantine, mandatory isolation. These are very significant restrictions, and this is a Federal Court of Canada case in Spencer versus Canada AG, which was decided at the federal court level, but now is on appeal to the Federal Court of Appeal. And in that one, they raised just about every charter section available because what was required was not only that you quarantine for 14 days if you cross the border into Canada, but also that you had to quarantine in a designated quarantine hotel. And this was argued as violating mobility rights under 6, but again, they said no, still a legitimate member of the Canadian population in a crisis time. Section 7, they said any violations of liberty were in accordance with fundamental justice. They tried a search argument, but said that doesn't apply. Detention under 9, they said the detention was not arbitrary. And as far as instructing and retaining counsel, in one case, they did uphold that because the person wasn't even told where they were going, so they couldn't contact counsel. But most of it was to conclude that even though these matters are quite drastic in nature, that's what's demanded by the times. And as I say, that's on appeal now to the Federal Court of Appeal, and it'll be interesting to see what happens with that. Next slide. So there's now also, in addition to the ones that have arisen to date that I've just talked about, there's a number of emerging and future issues in respect to COVID and the pandemic. And as we've seen many times, the landscape of COVID-19 itself changes very quickly. And as it changes, the legal issues change as well. And that's part of what we're seeing. The Delta variant, which is much more contagious, raises new issues compared to the earlier stages. And it just as another couple of examples, some of the early challenges started by the Canadian Civil Liberties Association will play out in the days ahead about enforcement. And one little known one that has been written about in some cases, a possible free speech or censorship case suggesting that doctors and other medical personnel in some hospitals and other health bureaucracies were significantly encouraged not to speak up. And one case in Nova Scotia where a doctor who did speak out against the policies or some of the policies of the chief medical officer of health was removed from his position as head of emergency medicine. So those are just a few of the some of the new legal elements. Next slide. The issue of vaccines and privacy concerns are huge. So I'll do a caveat and say all I'm going to do is raise some of the key issues. There'll be books and conferences and all kinds of articles written about that. So I'll just start that process in a small way. And the first thing that struck me on this one is why that is such a divisive and emotional issue. In my quite not large number of years in the area of constitutional law, I can't think of very many issues that have been so hard fought and emotional on all sides. And my assessment was that there's kind of three major reasons for that. One is that vaccines offer the best hope of returning to some degree of a normal society. So those supporting the vaccines are really attached to that, and related to that, that it's a very important protection for those that are trying to survive the COVID experience. The second one is that there's an interesting debate about the scientific evidence. And this is a larger issue written about by Lee McIntyre in an interesting little book called Post-Truth, that in this day of the internet and access to information online, that it's also access to disinformation, and that people tend to go to groups of like-minded people to get their information. So what you really have is people on both sides that have very different accounts of what the scientific evidence is. So that's really, I think, a big part of the dispute and why people hold so strongly to their beliefs. And thirdly, and finally on this, the invasions that come with the vaccine of liberty and privacy are great. Great restrictions on liberty, great restrictions on your privacy, so that the people who are concerned about that see this as kind of the thin edge of the wedge and the heading towards tyranny. So people opposing vaccines feel it strongly; those supporting it feel it equally strongly. There's one little case called the Dan Savar case, which does deal with the distribution of vaccines in Ontario. And basically they supported what the government said with saying what you'd expect them to say, really, which is that basically that's a matter for the politicians unless it's really outrageous. Much more controversial, mandatory vaccinations in employment. And this, of course, is a big issue, heavily factually contingent. Whether you're unionized or ununionized makes quite a difference in terms of resistance, whether it's public or private, the application of the charter, how much exposure to the public of individual employees if they're being mandated to have a vaccination, and also the number of vulnerable people in the population that is there. So those are some of the factual matters that are critical. It's also an area where there's a lot of different fora for remedies, not just the courts, but human rights commissions, where issues of accommodation will be big based on argued disability or creed, or in Nova Scotia, an odd little provision about irrational fear of contracting a contagious disease. I think most would say that it's probably rational here, so that might not fit, but those are ones that might arise. Labor boards are going to be called into action on this one, privacy commissioners as well. So there's a range of different possibilities. There haven't been many cases, or really any cases to date, other than one from police in Toronto that I think may have been started. Next issue is vaccine passports or proof of vaccination, and that is also highly contested. And that is one that happens to be starting today in Nova Scotia and now playing out in most provinces across the country. That too will be challenged under human rights codes for accommodation, and any passport or proof system builds into it accommodating people who, for medical reasons, legitimate and provable medical reasons, can't get the vaccine. So that's already covered, but there might be some other challenges there as well. It's also challenged, will likely be challenged under Section 7 and 15 because it creates sort of two classes of people, those with passports who have access to it. But I think at the end of the day, that it will be upheld in most cases, obviously depending on the details. First of all, it's temporary, or at least as temporary as the crisis. Secondly, it's only non-essential things like gyms, restaurants, sporting events, those kind of things, not essential services. For example, surely we couldn't apply that to hospitals or those kind of vital government services. And thirdly, I think that's really important that the technology does allow, I think, and people who are more knowledgeable than me on privacy, ways to do this with minimal invasions of privacy. So I, at the end of the day, would think it will not be struck down. Others agree with that. The C.D. Howe Institute did a study and made that same conclusion. And one lone case from the Ontario Human Rights Tribunal also upheld those kind of passports and vaccination mandates. So I think that that's where that one sits, although we're going to hear a lot more about that. Privacy concerns, lots of privacy invasions. Not only are you being injected, although I think it's important to say you're not being forced to be vaccinated, you're faced with a choice that then gives you fewer freedoms than those who have been vaccinated. So it's really, it's a situation of choice, but one that has big consequences. Can you ask people whether or not they're double vaccinated? I think you can, but that'll be debated. Obviously, that's personal information under various privacy laws, both at the public level and through PIPEDA at the private level, but there's always exceptions for threats to public health and contagious diseases. And again, like the Section 1 balance, I think that's where it's likely to come down. So not to in any way minimize the privacy concerns, but I think with the technology and the models that are out there, we should be able to do it in a way that's appropriate. The objective is clear. It's the means that are important. Next slide. Concluding thoughts on this large and difficult area. First of all, perhaps to state the obvious, the COVID pandemic is a major test for the rule of law. And I think that many countries will and are responding differently, and it will be interesting to see how Canada does and how the rule of law as part of our fundamental structure does. And I guess we'll see that as it plays out over time. One of the arguments, particularly for those who support more protective restrictions, is that in these pandemic times, the good COVID citizen is one who does wear masks, does social distance, does get double vaccinated, unless they can't for health reasons, and that's really what citizenship means, that's part of looking out for our neighbors as well as ourselves. However, there is an alternate version of reality, that this acceptance of all these restrictions and rules is really suggesting that we're travelers on the road to tyranny, that this limitation of our rights will not likely end anytime soon, and that the surrender of those rights are even more significant than catching COVID-19. Those are the two conflicting versions of reality that have to play out. I think, again, and I've kind of stated this throughout, that the reasonable limits on rights, whether directly in the Charter or others, will prevail in many, not all the cases. They can go too far in some cases, but in many cases, because they're supporting the health and well-being of Canadians generally, and that the courts will recognize that, as has the legislatures and executive level before that. But there is still a very important role for the role of law to deal with some of those cases. Next slide. And final slide, in an attempt to be somewhat briefly optimistic, I guess, although it's a question mark optimism, maybe in the days, months, and years ahead, when we finally leave the pandemic and COVID-19, perhaps we will be more caring and empathetic and better people, and we as a nation will be a more caring nation. That's my optimistic hope. So thank you very much for your patience.
Thank you very much, Wayne, for giving us this excellent overview of the key legal issues which this pandemic has brought about. So many of these issues that you raised could actually be a lecture in and of themselves. So you've given us a lot to think about, and I'm really looking forward to the discussion with the panel. I'll now introduce the two members of our panel. First, former Justice Thomas Cromwell. He was a professor at Dalhousie Law School for 15 years. He was then a member of the Nova Scotia Court of Appeal for nearly 12 years, and as many of you know, was a member of the Supreme Court of Canada for 8 years. He is now senior counsel at Borden Ladner Gervais and on the arbitrator mediator roster at Arbitration Place. Thanks again for joining us, former Justice Cromwell. I'm also delighted to introduce you to Sherry Pictou. She is a Mi'kmaq woman from Lisitkuk, which means water cuts through high rocks, known as Bear River First Nation, Nova Scotia. She's an assistant professor in the faculties of law and management at Dalhousie University, focusing on gender and Indigenous governance. Dr. Pictou is also a former chief of her community and the former co-chair of the World Forum of Fisher Peoples. She is a member of the Intergovernmental Science Policy Platform on Biodiversity and Ecosystem Services Task Force on Indigenous and Local Knowledge. More recently, she became the first female district chief for the Confederacy of Mainland Mi'kmaq. So without further ado, I'll pass it over to you to begin, former Justice Thomas Cromwell.
Thank you very much, Manette, and thank you, Wayne, for a stimulating and very broadly conceived overview of this fascinating topic. And thanks to the organizers for the opportunity to be part of this panel. I think that as Wayne's talk and paper have demonstrated, the pandemic provides a very useful lens through which to focus on the rule of law and some of the many issues associated with the concept. I'd like to widen the focus a little bit and say a few words about some of the implications of what Professor MacKay has said for the underlying principles of the rule of law. And I'm anxious to do this because I believe that the rule of law is facing some important challenges that we need to pay more attention to. I'd like to make 4 points very, very briefly. The first point is concerned with going back to the question that Professor MacKay touched on, and that is, what is the rule of law? And I think it's at least implicit, if not explicit, in what Professor MacKay has said, that he has adopted what has been dubbed a thick understanding of the rule of law as opposed to a thin understanding. And I just want to say I completely agree with him and say a word or two about why. The so-called thin conception of the rule of law is purely positivist. Law is whatever results from the official process that exists from time to time for making law. On this conception of the rule of law, a duly enacted law instituting slavery is just as much in conformity with the rule of law as one abolishing it. But this understanding of the rule of law is, I think, for most people, quite unsatisfactory. We balk at the notion that we could celebrate a concept which can authorize both oppression and even genocide. Contrasted with a thin conception of the rule of law is what some have dubbed the thick understanding. And this view holds that the rule of law must embrace the protection of human rights. The challenge, of course, is to define what protections are essential and how far they extend. The deep question, I think, is how to resolve a critical tension between, on one hand, that notion of a deeper or higher law, and on the other, the basic tenets of democracy rooted in majority rule and consent of the governed, or as we often put it, the tension between the rule of law and legislative supremacy. And as Wayne was going through the case law, it struck me how, in a certain way, positions that you might normally ascribe to people at different points on the political spectrum have almost shifted around, in that in one sense, the more progressive elements in society are quite supportive in general of pretty intensive government restrictions on individual freedoms. And those with whom we'd associate a more conservative view have suddenly decided that duly enacted laws are unjust and need to be challenged through civil disobedience and in other ways. So the reason that I want to just pause on this for a moment is that I think it underlines how the rule of law can simply become a slogan to support one's preferred view of how to reconcile that tension between individual freedom and legislative supremacy. I think that legislative supremacy is the main feature of the rule of law for some, while constitutionalism and adjudication by an independent judiciary is key for others. But I think that Wayne's talk really shows us how the truth of that probably lies somewhere in the middle and requires a lot more thinking about than our initial reaction to the concept of the rule of law might suggest. I think this much is clear, that in Canada, our conception of the rule of law is much closer to the thick than the thin version, to which I referred a moment ago. We have a constitutionally entrenched Charter of Rights that not only guarantees, subject to reasonable limits, fundamental human and democratic rights, but charges the judiciary with its interpretation. Moreover, and as Wayne mentioned, one of the animating principles of our Constitution is the protection of minorities. So I would conclude in brief that the rule of law in Canada is not just concerned with whether a body of law exists that applies to all and is reasonably clear and stable. Our understanding of the rule of law also includes the notion that laws should conform to and protect fundamental human rights. In other words, our understanding of the rule of law extends well beyond what I might call the rule of rules. The second point that I want to touch on is that we have reason to be concerned about the health of the rule of law in our country and elsewhere. I think many of you, like me, watched events of January 6th in Washington, the storming of the Capitol, with horror, revulsion, and most of all, profound sadness. But I fear that many Canadians also watch those events with a somewhat smug self-confidence that, well, that would never happen here. Well, I hope and pray that those Canadians are right. There are good reasons not to be smug or overly confident. Ensuring that democracy and the rule of law can withstand its challengers is hard work. And I believe that, at least as I see it, we have quite a bit of work to do. Do people perceive that the rule of law is something that's important to them? Ultimately, the ability of our institutions to carry out their roles depends on public confidence. It seems that everywhere we look, we sense that many people feel alienated from our foundational institutions and the so-called system that, in their view, is not serving their interests or, in many cases, even hearing their legitimate concerns. In short, I believe that many people simply don't see themselves in the picture of a country committed to respect for human rights and responsive democratic government. They doubt that one law applies to all, at least in practice, and the substantive equality that they may hear about doesn't respond to their lived reality. I fear that in addition to this feeling of alienation, or perhaps more likely because of it, there seems to be quite widespread apathy, as if many believe that the effective or ineffective functioning of our public institutions has nothing to do with them. Too many of us, I fear, feel entitled simply to be critics, as if we were commenting on a performance or grading an exam. But this detachment from how our life together is being governed is deeply at odds with the demands of democracy and the rule of law. Both, in my view, demand some level of collective responsibility of citizens. And yet one senses that many citizens feel as if they have no responsibility for or even a stake in what ails their democratic institutions. Too often we seem preoccupied with the politics of division. The focus seems too often to be on what divides us rather than on what unites us, on who we should fear or who we should blame, or how we can win. But democracy requires and indeed depends on compromise and respect for the views of others. I doubt that this idea was ever better expressed than it was by John D. White, who was at the time the Deputy Attorney General of Saskatchewan, making submissions to the Supreme Court of Canada in the secession reference. He said in part, and I quote, "A nation is built when the communities that comprise it make commitments to it, when they forego choices and opportunities on behalf of a nation, when the communities that comprise it make compromises, when they offer each other guarantees, when they make transfers, and perhaps most pointedly, when they receive from others the benefits of national solidarity. The threads of 1,000 acts of accommodation are the fabric of a nation." End of quote. I fear that we are not contributing many threads to that fabric. And just as the rule of law is key to a democracy, so is democracy key to the rule of law, at least to the rule of law in any form that's worth preserving. So cynicism, apathy, and unwillingness to engage in compromise are all challenges, perhaps even threats to the rule of law. And I suggest can be seen in various ways in what has happened during the pandemic. Another threat, or at least challenge, is a refusal by some to extend to others the rights that they claim for themselves. We see examples of groups who see no irony in their own assertion of their rights of free expression, while at the same time offering justification for their own suppression by force or intimidation of the expression of others. This may be effective activism or savvy exploitation of the media, but it is corrosive of the rule of law and undermines democracy. A final challenge is that we seem to be perilously close to abandoning any commitment to truth in our public discourse. We too frequently hear about that we live in the post-truth era, and we have a new word, truthiness, to describe much of our public discourse. Truth risks being replaced by what can be said loudly enough and often enough. Now, of course, free speech is a bedrock democratic principle. And of course, what constitutes truth is often contestable. But it is also true that every right brings with it some measure of responsibility. I worry that some people and groups are able to peddle outright lies, magnified through the megaphone of the internet, and to do so without meaningful opportunity for counter-narratives to be heard. When thousands, if not millions of people in the United States actually believe that their country is controlled by a group of Satan-worshipping pedophiles, there is surely reason to think that truth has been buried in lies. All of these challenges go to the foundation of civil society that allow the rule of law to function. To the extent that our collective commitment to democratic values and human rights is undermined by alienation, apathy, an unwillingness to compromise, and by unchallenged lies, so too is threatened both our commitment to and our collective ability to operationalize the rule of law. My third point, we are still struggling with what the rule of law means in the administrative state. This is particularly important for the legal aspects of our response to the pandemic, a great deal of which, as Wayne has pointed out, has been the result of the use by officials of delegated powers rather than through the enactment of brand new statutes. For some, it seems that the rule of law means that officials must exercise their powers the way a judge would. For them, the rule of law is equated with robust and interventionist judicial review of administrative powers. Others have a more nuanced understanding of the relationship between the judicial and administrative roles, leading to a more deferential stance towards administrative decision-making. But a question to be considered, and I'd welcome Wayne and Sherry's thoughts on this, have we yet developed a sufficiently robust approach to the judicial review of administrative action that nonetheless allows officials to use their powers in the public interest, free from undue judicial incursion? Some might argue that the answer is no for two reasons. First, we seem to be returning to a greater role for correctness review in the courts. Review that essentially requires judges to substitute their own views of what the official should have done for those of the official who actually exercised the power. Second, even the more ostensibly deferential review for reasonableness in the courts of administrative decision-making, where that applies, is nonetheless so open-textured that it too ultimately serves as a vehicle for the imposition of judicial preferences. While in one sense these are pretty theoretical issues, they're also crucially important ones when administrative authority is used in relation to matters of life and death, as they are during this pandemic. Let me conclude with a fourth point. We need to think about how the rule of law has fared in important emergencies and crises. I think history would not be on the side of the rule of law, but I'll leave that to the historians and people who are much more versed in legal history than I am. It certainly could be argued, and again, I hope to hear from Wayne and Sherry on this, that the courts have traditionally been quite deferential to the government in times of crisis and emergency. Do we have in place a way to ensure meaningful oversight of legality while nonetheless affording government the elbow room necessary to cope with unprecedented threats to our collective and individual well-being? Having lived through the legal aftermath of 9/11, and now being in the midst of the legal aftermath, well, not even, I guess, yet the aftermath of the pandemic, I think there are many serious questions to be asked about how well our legal institutions can cope with those kinds of unprecedented crises. It may be, too, that the challenge is as much concerned with facts as with legal principles. Can courts be better equipped to deal with important scientific controversies, for example, or should they be? On the one hand, we risk having the courts simply attorn to the opinion of scientific experts, but on the other, we risk having judges trying to become amateur scientists. One thing I'm quite sure about, though, is that the tools that we currently use for presenting contested science to the courts are probably not up to the task. So those are my brief thoughts resulting from a study and now hearing Wayne's paper. And I look forward to hearing from Sherry and ultimately again from Wayne. Thank you.
Thank you very much. I think I'm on here. Yeah, thank you very much, former Justice Cromwell. Those words were incredibly thought-provoking, inspiring. I think they should be heard and considered by many, and hopefully by this recording they will be. I'll now turn it over to you, Dr. Pictou, for your comments.
Thank you very much. I'm wondering, how can I live up to these two, astounding individuals, former Chief Justice Cromwell and Professor Emeritus MacKay. Both have provided some great insights, and particularly Wayne in his talk about, the issues for enacting the checks and balances and applying the law in efforts to balance its individual rights with collective rights and efforts for balance in public health measures with the economy. So many contradictions lie within those two broader efforts. And also, not to mention the contradictory issues, especially regarding the involuntary and voluntary vaccine mandates and mask wearing. But what I want to raise is probably even more questions that I think are related and issues that arise in what I term as cracks or shortcomings of the law. And of course, we all know, as an Indigenous person, I've experienced that there's been quite a difference to what the court upholds and then how that decision is implemented. So there is sometimes a major contradiction between the law and the legislators and the government of how that gets implemented. While much of the focus, particularly in recent days, has been on the anti-vaxxers and the anti-maskers, I want to think about what about the treatment of the already existing marginalized people, those, as Professor MacKay mentioned, who are homeless, those who did not have homes to go to, those in prisons. And as we know, there's a disproportionate number of Indigenous people and even an increasing number of Indigenous women in prisons, people of color, seniors, elders, etc. Now, regarding the treatment of Indigenous peoples in Nova Scotia, I can personally attest that the pandemic response was much better, especially in addressing leadership concerns and keeping the leadership informed about both federal and provincial protocols and processes for making vaccines available to Mi'kmaq communities. This is quite an improvement in comparison to what we witnessed in 2009 with the H1N1 crises, where the government sent body bags to First Nations in northern Manitoba. For those First Nations in Manitoba, this signaled that they were on their own. Although it came out afterwards, this was supposed to be a standard procedure of Health Canada, but it was still a shock to those First Nations. And Professor MacKay mentioned, the rule of law when we talked to the constitutional powers of 91, Section 91 and 92. And I just want to briefly point out that this has always been a real challenge for Indigenous people, because as I hope people have now learned, that when the Constitution, even going back further than that, was struck, or Confederation was struck, they did not know what to do with Indigenous people. We were wards of the state. We didn't have no rights. We weren't persons, and nobody wanted us. And so we came under federal jurisdiction. And so this has led to a jurisdictional nightmare today in terms of who has jurisdiction. So I just wanted to point that out. And as we're always caught between the federal and provincial jurisdictions. But even with my testament, and I was talking to some other leaders of who felt that the provincial and federal government responded well, as well as the chief medical officer, to their concerns here in Nova Scotia, we still must also come to terms that many First Nations still do not have safe drinking water. And for some First Nations, the impacts of the pandemic were compounded by climate change events, such as the increase in wildfires that we witnessed out west. And as Professor MacKay had alluded to, in terms of the homeless not having a home to go to, so isn't washing your hands. And if you don't have safe water, so those were some of the contradictions. Overall, the pandemic itself and the official response to it has revealed, as my colleagues have said, and starting with Dean Cameron, the pandemic itself exacerbated these existing inequities in our society, calling into question the legal debate about the efforts of legislators, administrators, in balancing the individual rights with collective rights. I always ask, whose individual rights are we protecting or striving to protect? Whose collective rights are we striving to protect? Whose freedoms? And what do we mean by basic or fundamental rights? And as we know, this big debate is one set of rights at the expense of certain groups of people. This certainly seems to be the case of anti-masks and anti-vaccines. Throughout this pandemic, we have witnessed, I would add, the racism, sexism, and of course, as Professor MacKay alluded to, the increase in domestic violence. And this pandemic also has certainly revealed a form of ageism within the disproportionate number of deaths among seniors, or what we in Mi'kmaq territory, who we refer to as our elders. We could argue that these were structural inadequacies in the operation of long-term care facilities, but we must also ask ourselves why those structural or operational inadequacies existed in the first place. Currently, with the unpredictability of this pandemic, and particularly the Delta variant, we are also learning that this virus does not discriminate against age, as there is great urgency to now create vaccines for children and youth. And on the other end of the spectrum, the issue of life necessary operations are being postponed. How do we measure those rights of those people due to the number of COVID cases, especially, as some would argue, against those who were unwilling to get vaccinated? And how do we strike a balance between the public health measures and the economy? And this is always been very perplexing to me, even without pandemic times. Like, how do we balance fundamental human rights against the economy? Particularly if we have unsustainable development within the economy that impacts those rights. The rights of small, as we've seen with this pandemic, the rights of small scales or small local stores compared to the large box stores. However, that said, what about the rights of those workers in large Amazon centers, or the food producers and harvesters, many who were temporary foreign workers, all serving the needs of Canadians? And not to mention, what about treaty rights? And as we witnessed in the last fall, that those treaty rights that's still going to be debated for years to come. And what about mega resource extraction projects, which has been determined as one of the many factors contributing to the disproportionate high number of missing and murdered Indigenous women and girls and gender diverse persons. During the pandemic, resource extraction sectors were deemed essential services, while the recommendations of the Missing and Murdered Indigenous Women and Girls Final Inquiry Report were put on hold due to the pandemic. And it will be interesting. I have not been able to stay on top of this and what have you, but there were certain cases in terms of camps, those large male-dominated camps of the coronavirus. And it'll be interesting to see if we'll ever hear about the impacts of those viruses throughout those camps, workers for resource in the resource exploitation sector. Overall, all the restrictions and with all their contradictions of individual or trying to balance individual with collective rights and the public health with the economy, even with all of that, this is very interesting to me that individuals were still afforded the right to refuse the vaccine. Does this impact the collective? And now we're taking all of these other measures in terms of vaccine passports and so forth. And it raises a very interesting question of why this particular pandemic, that the vaccine was voluntary in nature, or taking the vaccine. So inclusion, I'm inviting both the former Chief Justice Thomas Cromwell and Professor Wayne MacKay to provide some thoughts on how, while the courts are consumed in applying the law regarding rights, particularly with those cases that we heard about tonight, and especially individual rights about those who choose or did not, or those who are arguing that they should not have to wear the masks or take the vaccines, will the existence nuanced shortcomings of the law regarding existing inequalities or inequities, both, and racism, ageism, sexism, and fundamental human rights to food, water, shelter also be addressed? These were inequities before the pandemic. They were exacerbated during the pandemic. And I think we have to ask ourselves some very serious questions about those existing inequities. Thanks. I'll leave it there.
Thank you very much, Dr. Pictou, for providing this a very important perspective on the impact of the pandemic on certain groups and communities, and for raising the reality of systemic discrimination in our society, which this pandemic has highlighted and which has more seriously and adversely impacted certain vulnerable groups. So with that, I'll open the floor to the entire panel for discussion.
Maybe I will start off if I can. Maybe first of all, I'll make a comment on Sherry's point or Dr. Pictou's point last, because she made that last. And just first of all, say I completely agree with your points, as I'm sure does Tom Cromwell as well, that the pandemic has made existing inequities worse. And one would like to think, and maybe at some point I'd be interested in both of your views on this, that maybe that after it is clearly worse, will we become a more caring and empathetic nation that finally responds? And that's a pretty optimistic view, not necessarily one I would want to stake the house mortgage on or whatever, but still it's an important question, I guess. And I think you're so right that it's not as though a lot of these new issues, these are new issues, and the whole COVID pandemic has given us a new lens to look at them, which if we're open to real serious change and being truth, if we're really open to reconciliation and truth and these kind of things, will we finally start to do more than we've done? I would like to say yes. I guess I'm reluctant to say that too enthusiastically, but maybe it's an opportunity to do that. I really liked your point about the exploitation resource business, and you hear a lot of especially, you know, maybe particularly in the West, it seems, in Alberta and places like that, that we're protecting economic rights, and that's why we haven't been as protective of people's health and so on. Well, that's a pretty strange choice to make. I mean, many parts of this debate remind me of climate change. It's like the climate change debate in a way as well. Is there really an opposition between responding to climate change and economics? Not in the long term, there's not. And in this case, I'd say the same thing, that in relation to the choice between protecting the health and safety of all people and having a more robust economy, it seems to me the choice is pretty clear. And for those provinces in particular who tilted the balance pretty heavily on the economy side, I think the results are pretty obvious. And as I think you suggested, Dr. Pictou, in that regard, I'm pretty happy to be in Atlantic Canada, where I think we were a little more properly balanced in my view. Quickly to respond to Tom's points as well, he made three very penetrating and important ones in terms of the rule of law. And the first one is really whether our agency review is adequate to really giving the administrative agencies more room to maneuver and do their thing, or have we still, by different names, really allowed our courts in reviewing these agencies to substitute their opinions? And I tend to share his cynicism that that's more where we are. But I think actually it goes back to, in some ways, John Willis, a classic name to say in Dalhousie Law, Schulich School of Law context, argued a long time ago that the whole idea of having administrative law being about courts reviewing boards has it all wrong, that we really should be looking at boards and agencies and what they can do differently and effectively that maybe courts can't, and so on. But I think we need to get more in that direction. And I think that more of a reasonableness kind of standard on that, depending obviously somewhat on the particular board, but I think that really we do have to resist some of the judicial imposition on that. On the question of whether or not in times of crisis, they struck the right balance, I think historically, like you, I'm not a historian on this, but I think that they haven't probably done all that well. They have been traditionally very deferential, and probably with good reason. There's maybe some small bit of hope in this particular crisis and future ones, that with the aid of the Charter, which wasn't around when we were dealing with World War I or World War II, that maybe we have more tools to work with. And if they're worked with creatively, we'll leave a little more room for finding individual rights violations. And in the cases I reviewed, there were a few cases, sensible ones in my opinion, like the Hasidic Jew one, where they said, well, let's interpret this in a sensible kind of way and not be too draconian, or the one where they allow visits to the disabled 14-year-old in the group home, saying, well, how much of a risk is that really causing? So I have some optimism that the kind of independence and the objectivity within limits of our judges compared to, say, the American ones give me some hope. And also the administrative agencies, privacy commissioners have a huge role to play in issues around the vaccine. Human rights commissions have an increasingly important role. So I have a little optimism on that kind of thing. Finally, just very quickly on judges and scientific evidence, I think you're certainly correct that there's room for improvement. And the only thought that I had after you raised that question was whether, with being very careful to not bias judges in some way, whether we should have some more training for judges off the kind that we've had more recently on issues of gender equity and non-discrimination and those sort of things, about scientific evidence and some of the pros and cons, without trying to turn judges into scientists, which I think might be too big a challenge for anyone, but maybe I'm wrong. We could, I think, have some useful discussion along those lines. So just very quickly, and I want to hear from you on your points, but those would be my responses to the issues that you raised. So I'm open to either anybody wants to add anything else.
Sherry, would you like to add something, or?
You go ahead, Tom.
Just one really quick thought that to come back to your point about differential impact of the pandemic. I think both you and Wayne have raised that in a compelling and important way. And one aspect of that, I think, is also related back to one of my preoccupations for the last many years, and that's access to justice, in the sense that, you know, we can have the best text describing our law that we can imagine, but if people don't have the means to implement it, then obviously there's a big gap, and that contributes. I don't think it necessarily entirely creates, because I think there are many other factors such as systemic discrimination and so on, but the lack of access to the means of enforcing legal rights is also, I think, an important contributing factor. And one of the most interesting points in all the reading I've done about access to justice is the idea that we need to really come to grips with the roots of the problem of inadequate access to justice. We have to develop a sense of collective identity among citizens. And one of the most striking quotes that I have come across was this one. It says, "Organized action comes about when private grievances are redefined as a community's shared social problem." And I think that part of the answer to the access to justice challenge, particularly as it relates to differential impact of events such as a pandemic, is that we have to try to redefine the nature of the problem. It's not that, oh my gosh, those poor people over there aren't getting their share. It's got to be redefined, I think, as this is our problem of an unequal distribution of goods in society, that it's a collective problem that we have to solve collectively. It's not up to them to simply find some way of convincing the rest of us to do justice. It's trying to also define justice collectively in those terms.
If I may, I just want to follow up on a couple of things, and probably in a very elementary way. I find this very interesting. I really appreciate those comments about the, even the inequitable access to justice. And this really has been, this has raised questions in my mind about the issues that you raised, Tom, about, is there adequate judicial review of how law gets administered? And then, of course, we have this this indifference or this reluctance of particularly of judicial forms, if you will, or judges to overstep their bounds on terms of that government piece, that the government administrators and so forth. However, that being said, because of the way that the power relations are structured in this country, and that there is such a hierarchy in terms of privilege and who can access the law and to whose best interest, I often wondered, where's the check and balance in that? In terms of, particularly when you have governments that are pro-neoliberal, pro-unsustainable development because they need to get the economy going at no cost and so forth. But also, in cases, what's really scary for me, and I pay attention to United States as well, and I don't think we're all that far removed from that as like we would like to think, but even with the reluctance of the Supreme Court or judges to get involved with the Roe versus Wade case. And so what we've had a complete reversal, even though, with all the different dynamics and so forth, but you can say in Texas, like Roe versus Wade has been turned on its head. And why the justices, were reluctant to interfere with that. And that's what scares me here. It's not that I want the justices to be God. I think we still have to have those balances and so forth, but we also have to take into consideration the power imbalances, the power dynamics, and those who cannot defend themselves or have access to the resources to defend themselves, as corporations do, by the way. And that's what makes it so difficult. And I'm just, this is, there's a lot of different issues here, in terms of even injunctions. Corporate injunctions far supersede, there's been studies on the supersedes, injunctions sought by Indigenous people, particularly when it comes to development. I know that I'm throwing a whole lot of eggs in the basket there, but I guess fundamentally, I'd love to really further explore your thoughts on this reluctancy of the judicial arm of not interfering with that administrative arm, and yet the administrative arm seems to be free at will to interpret what the judicial arm does. And that's what I've experienced in treaty rights. What our perception of treaty rights gets misinterpreted down the road. I'll just leave it there. That was a lot that I threw at you.
Tom, do you want to respond to that? Well, just a couple of things, and I'll let Tom respond on another part of that. But I mean, I think, again, that's a huge issue that you both raised in terms of access to justice, and it probably being unfair. It's one odd little case, but that case I referred to of I think it was a guy who challenged the discarded masks as a nuisance and $565 million challenge. I can imagine, and Tom, you would have experienced this in a more direct way. I'm sure the judges were not very amused by that. I got that sense and how quickly they dispensed with it. I meant to check more closely and I didn't. I would kind of hope that he was probably unrepresented. I might be wrong, but at least in setting that kind of a figure. Now, in a way, I don't mean to pick on him particularly that case, but it makes your point. What access, who has access, and access for what kind of issues to our valuable and limited judicial and administrative and other kinds of resources? And that is a really big question, and probably even a bigger question during COVID-19. How many terrible cases never got anywhere to be adjudicated, like some of the ones I listed off, you know, and in fact, a number, not all, but a number of the cases that I talked about were supported by sort of foundations or groups who are particularly dedicated to liberty kind of concerns, and churches and others. And again, not to put anybody down, but are those who are most disadvantaged and those who are most impacted actually having any access to remedies at all? And that's partly, and former Chief Justice McLaughlin talked about this, that's partly why the Charter and the rule of law is not a monopoly in the courts, because at least one advantage to some administrative agencies is easier access for people without as much money and so on. But even that only goes part way. And your point, Sherry, sometimes those administrative agencies may be much more biased than the courts themselves. I was trying to think of a logging case in BC where they were trying to bring it before a logging commission, but it had already made pretty clear rules against the Indigenous claims, so they wanted it in court. So it's not a simple question. So, Tom, I don't know.
I think to sort of tie this back to the theme of the rule of law, I find that in administrative law in particular, that rule of law can be a real code for very different things. And I agree with Sherry that defining the correct role for judges in reviewing administrative action is not a simple thing, as our complex and apparently ever-changing jurisprudence on the subject, demonstrates. I think in my legal career, I think I'm now on my 4th reset of the standard of review analysis, and I hope that there isn't another one. I don't wish for premature death to avoid that, but I'm hoping that we have some period of stability. But the point, I think that itself underlines how sensitive that question is, because as you implied, in a sense, many administrative tribunals are simply arms of the executive branch. They exist to implement government policy as expressed in statutes. And while they are to be independent adjudicators and provide fair hearings and all those sorts of things, as the Supreme Court itself has said, administrative tribunals are an arm of the executive branch of government. And so when we're talking about judicial review, we're really talking about where those swim lanes are, if I could put it that way, for the judges and the elected representatives of the people. And it's not a simple question, obviously. One thing I think that's important to remember, though, is that at least in constitutional matters, where it's alleged that a decision of an administrative body is violating the constitutional rights of somebody, courts are not particularly deferential. And if my reading of our decision in Doré is correct, we're even less deferential, where discretion is exercised in a way that interferes with charter values, as the court coined that term. And I think, at least from my perspective, part of what that simply means is that courts, administrators in exercising discretionary powers, have to think about the values that underlie our commitment to human rights, protection of minorities, and so on and so forth. And that if they fail to do so, that may be an independent ground of setting aside their decision, even if a clear breach of the Charter of the Constitution isn't identified. When we get into interpreting ordinary statutes with no constitutional issues, I think it gets much harder, in the sense that, to be fair, the judicial record in areas of social reform legislation is, to put it charitably, quite mixed. You know, the judges kind of made a mess of workers' compensation. They had a pretty good go at ruining modern labor relations law, to the point that it required legislative intervention and really the establishment of a separate system administered by people who understood those specialized areas of work. That doesn't mean that there's no role for courts, but it suggests that if we think that we're going to rely on judges and courts to lead the charge on social justice, we're probably barking up the wrong tree, other than in the area of a robust interpretation of the Charter and of human rights legislation. So I mean, we could talk about this till tomorrow at this time, so I'll shut up there. But it's a fascinating subject, and I think a lot of this is going to come to play in the pandemic because we have very robust powers being exercised by what we would call statutory delegates, people exercising authority under broadly worded statutes and regulations. And we have an emergency, and we have big impact, as Wayne has so ably demonstrated, on personal freedom, privacy, and so on and so forth. So I think we're bound to hear quite a bit more about this tension than we have so far.
I wonder if I could change the gear just a bit, gears a little bit on this, and try to put the both of you on the spot to ask where you come down on my last attempted hope at our note of some possible optimism. That two questions, I guess. First of all, will we emerge from the COVID pandemic? Let's hope we will sometime in some form. But when we do, if we do you think is it at all realistic to think that Canada as a nation will be a better nation and we as individuals may be better individuals, or is that pie in the sky? Whoever wants to start with that simple little question.
You, Sherry.
You sure see the passing of the buck on this one. Yeah, I'm of both camps. I'm optimistic and pessimistic, and I have to be optimistic, particularly for the youth and particularly for students. They're inheriting a world that I wonder sometimes, will they question? I'm quite sure they're going to question, particularly the climate crisis that we're going to be leaving the world in and so forth. However, having said that, I am very optimistic, despite all the issues that we see that youth are dealing with. I've seen some very innovative youth, and particularly in my own Mi'kmaq community, in terms of some initiatives, in terms of a resurgence of some of those particular values that were not allowed to exist, or the ceremonies that were not allowed to legally exist. Like these were banned up until 1951 and so forth. But I'm very optimistic in seeing that resurgence and that type of leadership amongst our youth in terms of applying those values to sustainable, like a different interpretation of what sustainable development is and so forth. But overall, to emerge from this pandemic, it will just be very interesting, because I think too, in Canada, as sad, it's sad, but to admit, but we have seen this dichotomy, this really broad spectrum between what constitutes freedoms and what not freedoms, and I have to admit that a lot of what's in the courts now, not all, they're very, how can I say this in a respectful way? They come from very privileged positions, in a sense, to be able to even take that. Again, just raising the issue of what happened to the people that were experiencing homelessness here in Nova Scotia. What happened, like we went under a fundamental murder, murder of several people, and those type of things. And I think that that's going to raise a lot of, I hope it raises a lot of reflection about how we kind of take life for granted, and what are some of the more positive attributes of this country and so forth. I you know, without sensationalize it, I'm just a little bit mixed, because I think on one level it has the pandemic has highlighted a lot of diverse point of views, a lot of inequities that we knew that exist. We've seen this with Katrina. We're seeing this now with Louisiana, like, you know, those type of emergencies. And yet there's been a lot of good stories as well. So I'm not sure. I'm trying to be optimistic, Wayne. I'm trying to remain optimistic. And, you know, I'm just hoping we come out of this with some insights of how to really move forward. And my fear has been, as we've seen, oh, people are so tired of the pandemic that we just want to get back to normal. And I don't know if that's even if that's an option. That didn't answer your questions. That's
No.
a long-winded way, but yeah, I'll pass the buck to Tom. Maybe it's something more profound.
At least you gave me a minute or two to think there, Sherry. No, but seriously, I guess two responses. One is, you know, it's interesting to me always that our first lead and in some ways still leading case on equality before the law, who was the plaintiff, a white male lawyer who wanted to practice law in British Columbia.
Yeah.
Not exactly one of the analogous, you know, the equality seeking groups that I think the framers of the charter probably had in mind. And so I don't have too many illusions that, of course, the legal tools that exist are often exploited by people who have much less direct need of the help. But on the other hand, some of those leading judgments have helped people who were very deserving of it. So while you know, we come back to the access to justice issue, but I guess as we'd say in Nova Scotia, rising tide raises all boats, so that even if it was the late Mark Andrews who led the charge on Section 15, his efforts have helped a lot of other people that came afterwards. Second of all, I guess I'm cautiously optimistic. I certainly understand the reasons why one might not be, but I guess I've seen the way that public institutions have coped reasonably effectively. I mean, I think I got my vaccinations up here in Ontario, and I was extremely impressed by the way that whole thing was organized and rolled out, and the compassion and care that people who were administering the doses showed, and how well behaved and considerate of others the people that were there getting the shots were. I've seen a lot of people helping neighbors who couldn't get out or couldn't get access to services that they required. So I've seen a lot, and the courage and commitment of a lot of frontline workers in just about every field, and the way that people who've faced extremely difficult economic times because of the shutdowns and so on, the way they've responded. So there's been just a lot of courage and generosity, I think, to celebrate. Whether that will have a long-term societal impact, I guess, you know, make us a better world, I don't know, Wayne. I feel like, you know, you used to be an angry young man, and now you're going all soft on us. But
there are words for that. I think less positive one.
But anyway, so I'd like to agree with you, and I'm cautiously optimistic that we won't be proven wrong.
Okay.
Well, thanks so much, panel. I have one question. Thank you, Dean Cameron, who is asking the panel, and we only have a few minutes left. Have we learned or learned again from the pandemic that our brand of federalism might be a bar to the collective recognition that Tom Cromwell identifies as essential to better access to justice? So I'll throw that out for the last few minutes to whoever wants to respond to that.
I'll start off briefly, and I'm not gonna. It's a good question. I can't answer it completely by any means, but one thing I will say in the paper the larger paper talk a little bit about the criticisms of the federal government for not doing more and using its existing constitutional division of powers in a way that could have perhaps saved lives in long-term care facilities by setting national standards, pushing the envelope a bit in terms of their peace, order, and good government jurisdiction, or even actually proclaiming their own emergency act as the provinces did, those kind of things. So I think there's hopefully some lessons there, but I'm not sure whether the provincial response was a big problem, but I suppose if you ask somebody in Alberta, or if you ask somebody in Saskatchewan or somebody in Manitoba, they would say it sure did. And I mean, there's perhaps one of the better illustrations that within Canada, that there was such different reactions in terms of protections and protecting the economy and those kind of things. And as a result, such significantly higher loss of lives that didn't have to be lost. I mean, I think one of the tragedies in any of the loss of life out of COVID-19 is properly handled. Now that we have the vaccine, at least, it's a preventable disease. But as Sherry raised, why are we as tolerant as we even are, and some would say not tolerant enough, of people not getting vaccines when the price is so high? And so I don't know if we've learned that. If we had another pandemic, which let's hope is not at all the case, would Alberta or Saskatchewan or Manitoba do it differently? Would other provinces? I don't know the answer, but it's an important question. So that's my thought.
I'll just briefly say, I know we only got a couple minutes left, that it is an interesting, again, like this pandemic is so full of many contradictions that I took a little bit of comfort in the fact of how fast the federal government reacted in terms of providing financial relief, particularly for students and youth and so forth. But on the other hand, not taken a stronger role in those various provinces. And it scared me a little bit, because it almost reminded me of the form of federalism that we see in the United States, that we have such differentiated outcomes across Canada. And that's a little bit scary to me. And I don't know, maybe we have to really maybe it's not the legal aspect, but maybe it is federalism in itself and how that operates, and particularly how that operates in respect to Indigenous peoples.
Two very quick thoughts, if I'm not overstepping the time limits here. The number one, I certainly don't have a brief for the federal government one way or the other on this, but I think we do need to remember that it wasn't very long ago that the federal government emerged from about 3 or 4 years of litigation about its carbon pricing scheme that resulted in strong dissents in 2 courts of appeal, a negative decision in one of them, and a 6-3 split on the Supreme Court of Canada on the use of the Peace, Order, and Good Government authority under the opening words of Section 91 of the Constitution Act to address what I would hope just about everybody would admit is a climate emergency. So, if that was a near thing, I don't blame them too much for, not rushing into something else. So that's kind of political reality. But to get back to Camille's question, I don't personally think that our federal system interferes at all with the sort of community sense of grievance that I was trying to allude to. I think that's a much more grassroots type of recognition, that when communities start to define something not as something that's bad that's happening to somebody else, but something that's bad that's happening to them all, that's the kind of collective reaction to inequality or differential treatment that I was referring to. And I don't think that our federal division of powers is really an impediment to that developing.
assuming that might be the end of the panel, I'd just like to add that it's been a delight to have this conversation with Tom and Sherry, and I appreciate that. So thank you.
Thank you so much. And I'm loving these references to climate change as well as another type of crisis that we may be dealing with, which may form the subject of a next lecture in terms of, restricting rights, and who knows where that might lead us. So I want to take the opportunity to thank Dean Cameron and Dalhousie University for partnering with ICJ on this event. And thanks so much to our esteemed panel for such an interesting conversation and discussion, for volunteering their time to prepare for this webinar, and for sharing their wisdom, their expertise, and their thoughts with us today. I think it's an incredibly important conversation to be having, and I suspect it's going to be continuing. I also want to thank all of you in the audience for joining, as well as Connor Falvey at DAL and others, and David Hebb at ICJ for helping set this up for us. It was an incredible inaugural lecture, and it's setting us up quite nicely and whetting our appetite for more of these to come. So thanks again, everybody, and have a great evening.
Thanks very much.
Bye-bye.
See ya.